The MCA companies are geniuses. Let's give them all the credit in the world. They have formulated a methodology that gives them all of the advantages over a bank. A bank doesn't take weekly remittances from a company. It's monthly. Sometimes on a line of credit, payments are non-existent. You pay when you can. A conventional bank may charge between, let's say, 7 and 12% interest. The MCA charges between 50 and 100% interest. So figure out how many weeks it would take for the MCA to get back their original investment. And if you do the calculation correctly, you'll find they get back their money, the original investment, fairly quick. Not the bank. Also, the banks are governed by federal laws. The MCAs at this point aren't governed by any laws. Certain laws in a state of New York, in Erie County, has given the MCAs a distinct advantage. But the rest of the country is starting to figure out in the courts of law whether the MCA is a legal entity, a legal loan, or not.
So what's the deal on the MCA loans? How does this process work of getting the money so quickly from a company?
In the cases I've worked on, the MCA asks for a limited amount of information and copies of the company's bank statements. Why they do that? I guess to make sure the company does exist, who their bank is in case there's a problem later. The MCA does not ask for any financial statements, not a profit and loss, not a balance sheet. And they make the loan, I guess, just from the bank statement.
So they're able to take that little amount of information, turn that company into a client to lend money out. What does the rest of the process look like? Am I looking at favorable terms with today's interest rates, or am I looking at a really big amount that I have to pay back?
You hit it on the button, Isaac. First, let me say that it is a typical contract with a lot of whereas and therefores and a lot of legalese and terms that I don't understand. But the one thing that's very important to point out is there is a section called personal guarantees. It may be hidden. It may be the smallest of small print. But when an entity signs for an MCA loan, the signer, the entity, the owner of the company is signing personally. So if that loan is not paid back, the owner is personally responsible. And these are many of the situations that clients come to me for help. But let me get into the deal. One client now needed money. So they went to an MCA for an advance and asked for $150,000. The MCA approved it within 24 hours and remitted $146,500, deducting $3,500 for the closing fee. All well and good. The company got the money. No problem so far. But the terms of the agreement required the company to pay back $217,500 over 24 weeks, paying $9,062.52 each week. So if you think about this in a summary form, the company received $146,500 and was required to pay back $217,500. The difference, the additional amount to be paid back, was $67,500. If this were a 1-year loan, not 24 weeks, the interest rate would be 46%. Do the math. Because it's 24 weeks, the interest is doubled, more than doubled. The interest is 96%. How's that for a mic drop?
That's too much.
Okay, so what does this mean to the company? It needed the money. It got the money. It solved its problem, whether it be payroll or some extraordinary event, some catastrophe. And it takes a breath and says, okay, I got through it. Now what? Now the company is paying back $9,000 a week. 9, 2 weeks, 18, 3 weeks, 27. Just keep adding up the cumulative. And the company has to ask itself, can I afford to make these $9,000 payments? And the answers are generally, it is really, really, really hard to do.
Let's say real quick that I'm a company who is in one of the situations we've talked about before. Cash flow, payrolls coming up, unexpected expense. But I'm confident in my ability to make money. Have you ever seen MCA loans actually work out for someone?
Isaac, to be honest, I have not seen an MCA loan work out for any company. Some companies defaulted after 3 weeks. Some companies defaulted after 10 or 12 weeks, but not one that I've worked with has made it to term. But to be fair, this is my practice. I help companies in trouble. I help companies in situations where they needed the MCA loan. They received the money, solved their problem, and now they're having cash flow problems in repaying the MCA loan.
So that interest rate is absorbent. The fact that companies can't cope with the terms of the cash advance seems ridiculous. How is this legal?
What a great question. And I have worked and asked many lawyers, somewhere around 7 to 10 lawyers, if they think this type of arrangement is legal. And the legality of it is sometimes based on the state where the loan was made. Because in certain states, when the company went to court and fought the legality, they won. In other states, they lost. So I think at this point, there is no clear determination if this is legal or not. If you ask about the differences between states, that term is jurisdiction. What is considered lawful in one state is not lawful in another. There are consumer protection laws, but again, it's based on jurisdiction. Usury laws differ from state to state. So again, we're talking about where the loan was made and what the remedies are for a company should they not be able to pay. Could they go to court and win? Yes. But remember, MCAs have money to pay lawyers. Companies often do not. So it comes down to finances. Does the company have money to fight this in court? Do they know how to fight this in court? What would the remedy be? I took the loan and I can't pay it? That's not an excuse. There are others that companies can use, but we can discuss that later in this video.
So let's say I'm in a state where they can get away with this. I've signed up for the cash advance. I'm on week 3. I'm that client that you described where I have to default. I'm just not going to make it. What happens next?
So let's begin with the payment process. I think, as we discussed before, the process for getting a loan begins with the company supplying a bank statement to the MCA. And payments are made via ACH, where every week the MCA ACHs the money from the company's bank account. So in my experiences, the first part of the problem begins when there's insufficient money in the company's bank account and the payment bounces. So the MCA, nicely, because they're very respectful, they call, email, and ask the company to make up the payment. The company, in most cases, gets their act together and makes the payment because they don't want to be sued by the MCA. And parenthetically, it takes cash away from the normal operations of a company, causing other problems, but we'll stay on the MCA problem for now. If the company cannot continue to make that, let's say in the case, the example we gave, it was $9,062 a week. So the MCA, again being nice, says, okay, for the next few weeks, we want 5,000. The company can go along with it because it's less than the 9,000 and they continue to make payments. If they can't make those 5,000 payments, then the problems start. The MCA says, hey, we need our money. And if you can't make payments, then we're going to have to get to the next part where we're going to have to start litigation. If the company could not make the payments continually, they will sue the company. They will try and get a judgment. The judgment leads to a levy by which the MCA can then take the money out of the company's bank account. And also, if it gets to the next step, they will sue personally the owner of the company. So there are two parts to the litigation: against the company and the personal guarantee against the owner.
I'm drawn to what you said there with going from 9,000 to 5,000 for their payment. It sounds to me like the company can negotiate. Is that true?
Yes. In fact, there are times when we've been able to negotiate moratoriums where I've called the MCA and negotiated no payment for a few weeks. But if the company at the end cannot continue to make payments, all we did was delay the inevitable. And the MCA is in a position where they're willing to be patient. They are very respectful until the time they recognize that the company is not able to make payments. Then the onslaught of litigation begins.
So what can you do? Let's say I'm at the very tail end of all that. I've gone through everything. It's coming at me, letters from lawyers, etc. What can I do?
Isaac, the question cannot be answered easily because of the jurisdiction issues that we spoke about earlier. Each jurisdiction has different laws, and resolution to many of the cases I've worked on has been different. So in some cases, the client sued the MCA hoping to get a resolution from the court that said the interest rate was usurious, and we're waiting for a result now from the court to see if they agree. In other cases, the MCA just walked away. I'm not saying it happens in every case, but I had an organic dry cleaner in New York where I worked with two MCAs, told them that the company can't pay, and we haven't heard from them in 3 years.
Wow.
In other cases, the MCA sued, and we're now in court. In other cases, they went right to the courts and sued my client personally. What happens then, you ask? I'll answer it before you ask.
Yeah.
So the first thing that I do is I ask my client for a personal financial statement. What do they own? Because if the MCA gets a judgment against them personally, the next step would be to send a marshal out and take the assets. What options are open? At that point in time, the same options are open for the corporation and the person to consider bankruptcy. I know it sounds horrible, but if people were to learn about the benefits of bankruptcy for corporations, they might see it differently. For personal bankruptcy, it's bad. But if you think about what you'd be saving in a personal bankruptcy, maybe your house, maybe your cars, it should be given consideration. Again, each case is different, and only after hearing the facts would somebody like me be able to make a correct determination about the best path forward.
In the past, we've talked about bankruptcy as a protection, as in you can protect as a result of filing. Does that also extend to the personal guarantees on the MCA loans?
The corporation is almost secondary on the MCA. Think about this. The MCA wants its money. If the MCA makes the determination that the company doesn't have money, where are they going to get it from? They can only get it from the person. Chances are, if a person owns a business, they're pretty well off in one respect. They have a house, they have a car, maybe they have some savings. And that's what the MCA is counting on as a backstop because they know that the companies that come to them for loans are in trouble. They can't get the money from a conventional lender. So where would they go? That's the reason for the high interest. That's the reason for the high weekly payback. It's a game of land grab. How fast can the MCA extract money from a company before it can pay it back? And the backstop again are the personal assets of the owner.
So that's really scary. I'm just going to come out and straight up say it. But I want to know, is there hope? Is this the end of the road for someone who's looking down the barrel of an MCA loan?
In all the cases I've worked over the years, and there have been many, I can't tell you how bad I feel for the owners. I have so much compassion for them because chances are they're in the midlife. They've worked hard all the years, and it could disappear in a heartbeat. All because they try to save their company, the jobs of their employees, their family life, and a lot of other things. So is there hope? There is. But the owner has to be prepared to suffer a bit, suffer in the fact that they're going to make a financial commitment to settling the problem with the MCA. Maybe it's going to be legal fees. Maybe it's going to be a financial settlement with the MCA, some agreement that allows them to keep many of their assets, but they have to be ready for a fight.
So where do you go for help when it comes to dealing with this problem?
Another great question, Isaac, because people go to their advisors, a CPA, a lawyer, and they're going to get advice that these accounts need to be settled in some form. A lawyer will talk about bankruptcy. They'll talk about negotiating a payment settlement. A CPA will do the same, talk about a settlement. But the real person to start with is somebody who's familiar with MCAs, examples, and experiences with how these things work and how they settle. So I would definitely recommend an attorney who will first recommend a CRO, a chief restructuring officer, to begin the process because it's less expensive and the CRO, somebody like me, has vast experience in dealing in these situations. I urge the owner to avoid bankruptcy at the outset. Use it as a last resort. If an attorney is primarily recommending bankruptcy, please get a second opinion. And what I tell my clients is, I have an opinion, I have experience, but I am urging you to get other opinions from other professionals. Why? It's your life. Any result that occurs from my work and others, you are going to wind up being responsible for, and you are going to suffer if it's wrong. Be comfortable with the advice that all of the professionals give you.